Good evening to everyone, and thanks for joining this session, our last one of 2025, where my name is Chris Ben. I'm an immigration lawyer with a firm called Seraphus, and we work closely with the EU delegation to the UK. And part of our work about EU citizens' rights in the UK post-Brexit and on the EU settlement scheme is we try to provide a monthly Facebook Live session where we update directly on Home Office policies and other policies that affect EU citizens and their family members living in the UK. And we answer questions via a Q&A section for those who join and want to clarify some information, quite often relating to the EU settlement scheme, but sometimes about other types of post-Brexit citizens' rights. So welcome if you are joining a session for the first time this evening. Hopefully it'll be helpful for you. And of course, if you've seen one of our previous sessions, welcome back. And I'm glad that you feel that it's worthwhile to join again and hopefully to hear something important about your situation or about your family and your friends in the UK. So what we try to do at the end of the year is have a little bit of a reflection on the year just gone and a little bit of a look ahead to the coming year. And I think in the terms of the EU settlement scheme and Brexit in general, it's quite an important year to have that reflection, because we are approaching 5 years since the transition period ended between the UK, and the transition period was essentially a period where EU law continued to apply in the UK, even though the UK had technically left the EU by that point. But EU law continued to apply until 31st of December 2020, and for the purposes of status under the settlement scheme, EU citizens had until the 31st of December 2020 to move to the UK and begin a residence period that would entitle them to apply for EU settlement scheme status. So a very significant moment in Brexit happened 5 years ago on the 31st of December this year. And so it has a practical effect, because many people who did move to the UK before the end of the transition period, and particularly if they came in the sort of latter months before the end of the transition period, will now be approaching 5 years of residence. And for those familiar with the settlement scheme, 5 years of residence is a really crucial moment, because you then hopefully can qualify for settled status, which is the permanent resident status offered by the EU settlement scheme. So many people who are on pre-settled status at the moment may be able to move to the permanent settled status in the coming months, and hopefully they'll be successful in doing so. And part of what we will talk about this evening is how the Home Office has, or some of the approaches the Home Office has taken to trying to ensure that people with pre-settled status are able to successfully move to settled status. And in that sense, 2025 has been a very important year, because some policy changes relating to the settlement scheme and the ability to qualify for settled status were introduced, and we'll talk a little bit about those. We did cover them when the changes were made at those moments within the year, and we did some quite detailed presentations, but we want to look back and remind people of where we are with those largely positive changes today, and hopefully it will allow people to understand how they can move from pre-settled to settled status. And as I say, we'll look towards some policies that are imminent in 2026, because again, it's going to be another big year and an important year. And it probably seems quite strange that we're sort of talking so much about important years that this far after Brexit, the 5 years, but in the citizens' rights area, it really is it's an ongoing piece of work, if you like, to make sure everyone who is entitled to those protections of the withdrawal agreement is able to access them, and to hopefully secure that permanent resident status. So there's a little summary. My colleague Caroline is running the slide deck and will also receive the questions. If you wish to post any questions about anything I talk about or about anything that I'm not talking about, please do so in the comment section, and then we will come to that after I've run through the presentation. We usually do this in about an hour, with the first half talking about the presentation and what I've included in there, and then another half an hour or perhaps a little bit less to deal with any questions. So very happy to receive those questions, and please feel free to post them. Okay, so the first thing on the list, looking back over 2025, is the introduction of what's called the automated process. And this is something that the Home Office, a process that the Home Office introduced in January 2025. And the idea behind the process is that pre-settled status holders can, in some instances, be moved to settled status without the need to apply to the Home Office to sort of make a second application, if you like, under the EU settlement scheme to qualify for settled status. So the idea of the automation process is you cut out the need for that second application, and the Home Office, if they are satisfied the residency conditions are met, then they will grant settled status without you needing to apply. So a positive change, because it removes that kind of administrative burden, if you like. So the process began, it went live. The Home Office was planning it for several years, and then they went live with their approach in January 2025. The process, I'll explain a little bit about how it works, because I think sometimes people are confused about how automation works, who is going to be successful, who might not be successful, and what does it mean if you're not successful. But essentially, the way the automation process works is it picks up a case based on the pre-settled status expiry date. So if you are someone who applied for your pre-settled status, let's say in January 2021, and you are now approaching January 2026, you will have an expiry date on your pre-settled status. Now, that isn't an actual expiry date, because the Home Office has to extend your pre-settled status and not allow it to expire. That relates to a different a legal case that was brought against the Home Office. But because the pre-settled status does have an expiry date that the system can identify, once you're approaching it, the Home Office system picks you up and it says, right, let's consider whether you can be automatically granted settled status. So what then happens is your national insurance number, if you have one, is checked against the government databases. And what this means is HMRC tax databases and the Department of Work and Pensions database. The Department of Work and Pensions obviously issues things like pensions and universal credit and so on. And so your national insurance number would be checked against those. And if those checks indicate you have been living in the UK for 5 years, then you are granted settled status automatically. So it's that simple if you have the national insurance records. If you don't have those national insurance records, or there's another reason why you cannot be automatically moved to settled status, then the outcome of the automation process is to give you another 5 years of pre-settled status. And it's really important to understand why that happens, because it's not a comment about whether or not you qualify for settled status. It is not the Home Office saying, oh, you don't have 5 years of national insurance records, so you don't qualify for settled status. All it is saying is, because we don't see the 5 years of national insurance records, we cannot give you automatically settled status. But you can have pre-settled status, and as I'll explain on the next slide, you can apply to qualify for settled status by using other means, not just national insurance records. And so what I'm trying to say in terms of automation is that there are limitations to it. It is useful for people who benefit, but it is limited by certain factors, one of which is whether you have sufficient national insurance records, and the other one is that some people just cannot be automated under any circumstances because of their circumstances. And that applies to under 18-year-olds. You cannot be automatically upgraded to settled status if you're under 18. And if you have been sponsored for your pre-settled status as a family member or a joining family member, then you cannot be automatically upgraded to settled status. And that's because, as well as your residency in the UK, the Home Office needs to assess other factors like where is your sponsor, the person who sponsored you for pre-settled status, or in the case of children, the Home Office has safeguarding responsibilities that they need to undertake before granting settled status. So those cases cannot be automatically upgraded to settled status. And what's a little bit confusing for people is that the Home Office will communicate with you even if you're one of these cases. So even if you're under 18 years old, you will receive communication to the Home Office from the Home Office to the email address that's linked to your UK visa and immigration account, and they will say, "Oh, we're considering you for automation." And what's not made clear is that you will automatically not be upgraded because you're under 18, so you're excluded. So the communications can be a little bit confusing for people. That's some of the feedback that we receive. And so what I'm trying to do is to kind of explain a little bit more about who gets to be automatically upgraded and who won't be, and will instead be given that pre-settled status extension. So if you want to understand some figures behind automation, the Home Office has granted 53,000 settled statuses automatically in roughly the last 12 months. It's a little bit less, obviously, because it came in, I think, towards the end of January, but 53,000 statuses. And if you want an idea of all settled status grants in the first 3 quarters of this year, you would see 196,000. So of 196,000, 53,000 are automatically granted, but that doesn't mean that it was essentially the process was successful in only sort of a quarter of the cases, because the Home Office doesn't say how many cases are considered for automatic grants. You would only be able to understand that if the Home Office said this many cases were considered for automation and this many got settled status. That's the figure they give you, but they don't give you the figure of these many people couldn't be automatically upgraded and so instead have been given a 5-year pre-settled status extension. So the data on automation doesn't tell you how effective it is, unfortunately. But as I say, because some people are automatically excluded and because not everyone will have full national insurance records, it means that there is definitely going to be people who need to apply for settled status when they qualify, and they're not going to be automatically upgraded. And so that's some of the messaging that we've been trying to reinforce for citizens and family members, is to say you might not get automatically upgraded, and so in some cases don't wait for that process because it's not going to help you. And instead, if you qualify, make that manual application and hopefully you'll be able to get that grant based on your application. There's no difference between the settled status granted under the automatic process and that granted to people who have applied. It's the same outcome. It's a grant of permanent status. Okay, so that's automatic grants of settled status, and I'm going to come back to that topic when we look at 2026 because there will be some important potential changes to the process. Now, one of probably the biggest thing that has happened in this year, and arguably definitely one of the top 5 things that's happened in the lifetime of the settlement scheme, is the Home Office changing the absence or the continuous residence rules, as they're referred to sometimes, for pre-settled status holders who want to move to settled status. It was a change that was made. It started as a policy from the 16th of July. And so if your application for settled status has been looked at from the 16th of July onwards, the Home Office will have looked at these new absence conditions. And what the Home Office did was, in addition, so the original absence conditions are that you would need to be resident for 6 months in every 12-month period for 5 years, subject to a few limited cases where you could be absent for a bit longer, for example, due to COVID-19 pandemic. But broadly speaking, you had to always be resident for 6 months in each 12 months to qualify for settled status. The Home Office has changed this, they've added to it, I should say, because you could still meet that original condition, but what they've done is they've added an alternative way to qualify, which is that in the last 60 months, so in the last 5 years, and that's based the most recent 5 years when the Home Office is looking at the application, you have been resident for 30 months, i.e. 2.5 years of residence. So rather than saying every year of your 5 years you must have 6 months here, what they're saying is over the whole 5-year period, you must have spent 50% of your time in the UK, a minimum of 2.5 years. But it doesn't matter to us if that you have like a long absence of 18 months at one point, as long as you use that 18-month allowance, and for the rest of the time you are present, as long as you sort of have another year's worth of allowance to use, but you don't go over 2.5 years in the last 5 years. So it's a much more straightforward approach. It's also very helpful because it's based on the date you applied for settled status. So it might be some people who can't qualify today. So someone, if you looked at your absences from the UK over the last 5 years today and said, oh, actually, I think I've gone over the 2.5 years. I've got maybe let's say 33 months. I've calculated my time and it's actually 33 months. What you could do then is spend the time resident in the UK and add your residency to your qualifying, which also adding residency will reduce your absences depending on when the absences took place. But the idea is that you essentially could qualify in the future, even if you don't qualify today. And that's really beneficial for people because that's not how the original 6-month and 12-month rule operates. It doesn't sort of allow you a second chance, whereas the new updated rule does allow you that possibility. So it's very, very helpful. The 3 Million organization, I hope you've heard of them. They're brilliant. They help advocate on citizens' rights, and they put lots of helpful information on their website. And they include on their website a calculator that helps you to understand if you have 30 months of residence. And it's like an Excel calculator, and you put in days you have been away from the UK, and it will give you a figure over the course of 5 years and tell you if you have 30 months of residence, or if you haven't got 30 months of residence, that it will give you a date that you would qualify, assuming that you build up more residence. So it's very, very helpful. I know a lot of lawyers use it to understand. It doesn't matter for you, obviously, if you don't have a lot of absences from the UK. If you don't have a lot of absences, you don't need to sit there and calculate, oh, well, do I have 8 months of absence in over a course of 5 years? We're talking about people who might be close to that 30 months, understanding their position. So it is a really helpful tool, and I recommend people look at it to see it, particularly if they're not sure what their situation is. One thing it's important to bear in mind about this change in the absence rule is that it only applies if you hold pre-settled status. So if you are someone who is, let's say you're a late applicant to the settlement scheme, and I'll talk about late applications in a minute. If you're a late applicant and you don't currently have status, but you're looking to make an application to say, I was living in the UK before the end of 2020, I'm an EU national, and I've been continuously resident here since the end of 2020, you will be if the Home Office accepts your late application, and they have to accept that you have a reasonable excuse for missing the deadline. But if they do accept to look at your application, they will then apply the 6-month in 12-month absence rule to your application. And so they will, that's how they will assess your application. So they won't look at 30 months of residence in the last 60 months if you do not already hold pre-settled status. So that's just important to bear in mind. And that is something that's important. I've put it down the bottom, something called lapsed leave cases. I don't propose to talk about lapsed leave too much because it's really, really complex. But ultimately, there is a sort of group of cases where people might be considered to have lost their pre-settled status due to absences that went over 2 years. And the Home Office refers to these as lapsed leave cases. And at the moment, the rules don't allow for these lapsed leave cases to qualify under this 30-month and 60-month rule. We understand the Home Office would like address this issue so that these lapse leave cases can qualify. That's what they've intended, or what they're intending, and we wait with bated breath for the solution. And as soon as we have that solution for lapse leave cases, which we're informed is going to be coming, then we will communicate that, because hopefully it doesn't affect too many cases, but there are definitely people who would be in that category, and so we need to make sure they're covered as well under this more generous approach to continuous residence. And the other thing to bear in mind about the 30-month in 60-month residence rule is that it is only applied in manual applications at the moment. So when the automatic process that I described looks at a case to see if someone has enough national insurance records, they are looking for 6 months national insurance records in the last 12 months. They're not looking at 30 months of residence over the last 5-year period, because the automatic process doesn't, the rules of the automatic process don't incorporate that sort of parameters at the current time, and I will return to that in a few slides time. So that is the change on the residence rules. It is a really positive change. It was something that came about due to a lot of stakeholder engagement with the Home Office. A lot of cases were put to the Home Office where people were being excluded from settled status through no fault of their own, to do with the COVID pandemic, etc. And the Home Office listened to the feedback and took a really positive and pragmatic decision to change the rules. So we're all very grateful for that feedback, and that there was listening there to make life easier for people who have made the UK their home. So it's a good news story in 2025. It was something that had caused people like me and my people who do my kind of work a lot of anxiety for a lot of years, that people would miss out on settled status. So hopefully it will reduce people who can't get settled status, because there are still going to be some people who can't move to settled status, but overall we hope that those simplified and more flexible residence rules do bring more people into scope for settled status. Okay, something just connected to this. I won't dwell on this too long, but just so people are aware, is that when the Home Office updated the residence rules to use the 30 months and 60-month approach, they also introduced what's called sort of the use of travel data into the manual application process. So this is not something that's connected to automation. It's just about if you are pre-settled status holder and you apply for settled status. The Home Office, if they cannot identify that you've been resident for 30 months in the last 60 based on your national insurance records, then they will look at the travel data that they hold on people exiting, entering the UK, because obviously the Home Office is responsible for the UK borders. And if that travel data and border data indicates that someone has been resident, and it fills in perhaps some of the gaps with the national insurance record, or if someone doesn't have any national insurance records, the travel data might, just on its own, be able to fill in the question about whether someone has been resident, and the Home Office will use this. And so it is the idea of using travel data is sort of complementary. It's another source of data to help the Home Office to establish people who should qualify for settled status. And the idea behind it is that before the Home Office, so if you don't have complete national insurance records, or you don't have a national insurance number, the Home Office, they will look at the travel data before they write to you and say, can you give us residence documents? They'll look at the travel data. And if the travel data indicates you've been resident for enough time, i.e. the 30 months in the last 60 months, then they don't need to write to you to ask for more evidence, because they can use the travel data to grant you settled status. So it's a way of reducing the burden on people who are applying for or for settled status who hold pre-settled status. So again, it's another positive policy that's been introduced, which we again hope makes life easier for people, and it does reduce those administrative burdens on people. So again, it's something that we think hopefully helps people. It's a bit hard to quantify how much it helps people because we don't see, we don't know exactly what happens when the Home Office looks at the travel data, but in principle, there's no reason why it shouldn't help people. But there is this important sort of thing to remember that I put in the last bullet point, is that Home Office travel data is not always accurate. There are situations where actually the Home Office data can indicate someone's not present in the UK when in fact they are. So for anyone who's been following closely the media stories about child benefit, which is administered by HMRC, they made some decisions about whether people were eligible for child benefit based on what the Home Office travel data showed. And what they were looking for were people who don't live in the UK anymore, because if you don't live in the UK, then you're not, in most cases, eligible for child benefit. So there was the Home Office travel data was used by HMRC to determine whether someone was resident or not, and in quite a few thousand, over I think there was at least 20,000 cases that were looked at. In the travel data was wrong in what it was telling people. It was saying people were not resident when in fact they are. So it's just something that we are very aware of because we don't know loads about the travel data. And obviously, if the travel data isn't accurate and it's indicating someone is not living in the UK when they are, then that would be a negative thing for that person. So we do need to kind of keep an eye on travel data and how it works, and ask more questions about how it's generated and why it might be inaccurate in some cases, because as I say, it's something that could be used positively for people, but it needs to be accurate and not wrongly show that people are not living in the UK. So there are still some questions about travel data, but it is something that's a good could be a good thing in the use in terms of reducing the amount of documents that you need to provide to the Home Office, or the amount of times the Home Office needs to write out to applicants to ask them for documents. Okay, the last thing I think I'm going to say on, I've got a couple more things to say on this year. Late applications, these are not a new thing. Late applications have existed almost for 5 years now, because the deadline for most people to apply to the settlement scheme was the 30th of June 2021, so we're up to 4.5 years ago. But the withdrawal agreement always has this kind of safety net for people who didn't apply in time, that if they can explain why they didn't apply in time, and it's what's called reasonable grounds for missing the deadline, then the Home Office can grant them. They can accept the application for consideration, and then if they qualify, they can grant them status. And so it's important. It's extremely important, because we know from the Home Office data that people continue to make late applications, even though we are 4.5 years after the deadline for most people, and we're talking in tens of thousands of late applications. And this is an indication of the fact that it's the EU resident population of the UK at the end of 2020 was not known. There was no very accurate data on that. People have estimated it, but they don't know. And so there are obviously people who have not applied, who maybe the communications about the settlement scheme missed them. Maybe they thought it didn't apply to them for some reason. Maybe they lived here for a long time and didn't think it applied. Brexit was a thing for other people. There's lots of different reasons why people might not have applied, but they still make these applications, and the Home Office accepts for processing a lot of these late applications. And therefore, we always want to reiterate to people, if you suddenly realise, even in 2025 or in 2026, that you should have applied to the settlement scheme, but you didn't because of reason X, Y, or Z, then it may be that you should be making a late application. We strongly advise people to take legal advice about late applications, because they need to be presented to the Home Office in a certain way. The reasons for missing the deadline need to be made very clear, and sometimes it needs to be evidence to back up that reason. So we do recommend legal advice if you can seek this, because it's the surest way to know that you can make a strong application, and it is important, because the Home Office might reject a late application. They don't have to accept a late application if they don't think there are reasonable grounds. And so it's really important that you present your information clearly to the Home Office, and obviously advisors who work in the EUSS field will be able to give you that clear advice. One thing just to bear in mind with late applications is children, because children born in the UK who are not British citizens, it's quite a complicated area of law to know whether children are born British or not, but some children born in the UK are British, some children born in the UK are not British. But if they're not born British, then, and you have two or a parent with EUSS status, the likelihood is that child should be applying for their own settlement scheme status. It's quite a tight deadline for them to apply from their birth, which is 3 months. That's what they're given to apply. It can be very challenging to get a passport within 3 months. And so quite often people are pushed into making a late application for a child because they couldn't get a document, or in some cases people don't realize they need to apply and things like that. So children's applications, late applications, are generally accepted by the Home Office. Very rarely do they refuse them, but we try to raise awareness of the 3-month rule, and also raise awareness that if you are going to struggle to get your child a passport within 3 months from your national authority, then you can contact the Home Office Resolution Centre. That's the helpline, the call centre the Home Office runs, and you can ask them for a paper application form to make an application without an identity document. So you can apply within 3 months using the paper form. But if you're listening to this and you're like, oh my God, my child was born 6 months ago and they need to apply, they're now a late applicant, you should still apply for them. The Home Office does accept the majority of late applications from children, and so they should be able to apply even if they miss that 3-month deadline. Okay, so that's late applications. So there's still a big and important area in the settlement scheme. I think it's important to cover what I've referred to as non-EU settlement scheme immigration policy announcements, because this has certainly been a feature of the second half of 2025, is that the UK government has made several immigration policy announcements, and other political parties have also made announcements based on what they would do if they became the next government in so many years' time. And so we do have a lot of information and misinformation, unfortunately, flying around about what will change in the immigration sphere in the UK. And it can be quite disconcerting and create a lot of anxiety for people, as you would understand, because most of the announcements are about restrictive policies, not about making life easier for people under the UK's immigration system. So what I guess I want to say, I don't want to go through like every announcement that's been made, but I just want to be clear that the EU settlement scheme is designed to implement the withdrawal agreement between the UK and the EU. That is its purpose. And so the rights that exist under the settlement scheme and the status that exists under the settlement scheme is rights and status under the withdrawal agreement. And there's been a lot of work, again, over many years from the EU Commission and engaging with the UK government to try to resolve some of the issues about who may or may not be a withdrawal agreement, have withdrawal agreement rights. And thankfully, this has resulted in this year a UK piece of legislation that has said, if you're an EU national, or if you're a family member of an EU national and that you hold settlement scheme status, you are treated as a withdrawal agreement beneficiary. So basically just simplifying what had become something that was quite complicated, and saying everyone is a withdrawal agreement beneficiary and has those rights. So you can now be assured that your status gives you this withdrawal agreement protection. And that's really important, because if the Home Office decides to change immigration policy in a certain area, and we can talk about settlement, because that's the Home Office proposals, is to increase the qualifying period for settlement from what's currently in most immigration routes 5 years to a 10-year period as the minimum amount, and then they might reduce that 10 years or they might increase it depending on the circumstances. And obviously people who are on pre-settled status become very concerned. Well, hang on, I thought I was going to be able to apply for settled status after 5 years. Am I now going to have to wait for 10 years? My family member joined me 2 years ago and has pre-settled status, but has a couple of years left to build up to settled status, are they going to be affected? And the simple answer in most cases is that these announcements that you hear will not affect your rights under the settlement scheme. There is no, the Home Office cannot increase the qualifying period to move from pre-settled to settled status to 10 years. They have to keep it at 5 years because that's the withdrawal agreement time frame. So even though it's not explicit, and I think it's unfortunately these announcements from the government, they don't make it always clear who's affected and who isn't affected, and they could be very much clearer about who's affected from the settlement scheme perspective. But so broadly speaking, most of these announcements are not going to affect people who fall within the settlement scheme, because of the withdrawal agreement being the kind of actual the source of their rights. It's not to say in every scenario that people with settlement scheme status can't be affected. So it's not, I cannot just say you're never affected. And sometimes it is important to understand and to look at information that is reliable in this area and to understand. And so there might be things that the UK government does that does affect people with status under the settlement scheme. And if you want an example, it might be to increase the length of time before someone can apply to become British. That might be something that the government does. And if it does do that, it is possible that they could apply it to people with settlement scheme status, because the withdrawal agreement doesn't really look at the nationality laws of the parties that are bound by the withdrawal agreement, the UK and the EU member states. It doesn't look into nationality policy. So that's just an example to say, in general terms, these announcements are not aimed at the EU settlement scheme group, but it's not, it's not every situation is excluded. And as I say, if you're going to look into this, try to look for reputable information, because it's there's an awful lot of misinformation, and I do feel a lot of sympathy for people being very confused about what's going on. The whole thing is confusing for people who are outside the settlement scheme as well, of course. Okay, so that's kind of what I wanted to say about 2025, and we'll look on to 2026. And so I'd already said about the automation process and how it might change in 2026, and this is because the main thing is about this updated residence rule, because obviously, because the 30 months of residence in the last 60 months is a more straightforward residence rule to me, it would make sense to apply it to the automation process so that more people can be automatically moved to settled status, because that's the purpose of the automated process. It's to move people who qualified to settled status. So if you've got someone who has completed 30 months of residence in the last 5 years, they can qualify for settled status. So it makes sense that the automation process applies to that person. But it is taking some time to bring in those new residence rules for the automation process. And so, but what we understand is that this is what the Home Office is planning to do in 2026. And so this is something that we'll look out for. And obviously, if it does happen, then we will update people, because we'll say, right, the automation process hopefully has improved and more people will be covered. And it may be that the actual process of automation, like what decisions are made, when they're made, what communication is given to people, we would also hope be a little bit tidier in that one decision is made and one communication can be made to people to either say you've been automatically moved to settled status, or your pre-settled status has been extended for 5 years because we can't automate you. So hopefully it will look a little bit more streamlined as a process, but also the big thing is include the new continuous residence rules, because that gets more people to be granted automatic settled status. Okay, there's that. So that's the first thing to look at. There is potentially plans on the horizon also for the Home Office to start removing pre-settled status from those who no longer qualify for it, because pre-settled status is obviously a temporary resident status, and so it allows people to reside in the UK and qualify for settled status, but only where they meet the conditions to qualify for settled status. And as we've talked about, for EU citizens, that mainly means being resident for 30 months in a 5-year period. But not everyone has been resident. People with pre-settled status might not live in the UK anymore, and they might have got their pre-settled status with an intention to live in the UK at the time, but decided, actually, I'm going to go and live elsewhere. And they might not qualify under the settlement scheme anymore. They might have effectively broken their connection to the UK, and that's absolutely fine, of course. But because pre-settled status, it has to be taken away in most cases. There's some possible exclusions there, but generally it has to be taken away from the person who holds the status. And so what the Home Office has indicated that they intend to do is to start looking at people who may no longer live in the UK, and if it's appropriate, to remove their pre-settled status. There are at the moment, the Home Office has other policies about removing pre-settled status, because, for example, if people's are sponsored family members whose relationship has broken down and they don't continue to qualify for status under the settlement scheme, can have their status removed. So that's policy is one that's live at the moment. The Home Office removes status if people commit certain criminal offences. That's another basis to remove the status. So it does already happen, but it doesn't happen at the moment for people who have been away from the UK for a long time. So that's what we're expecting to see in 2026. Before the Home Office takes away any status, they need to communicate with people. They need to ask them about their situation, because they can't assume that they don't live in the UK anymore. We just talked about travel data not always being accurate. So the Home Office can't assume people haven't been living in the UK, but they will look for indications that people aren't living in the UK, and they will engage with them, and then they will make a decision about whether the person has in fact got these excessive absences. And if they have those excessive absences and there's no reasons why they shouldn't lose their status, the Home Office would then take it away. That decision to take it away is subject to an appeal. So you can say, no, I think this is wrong for me. I'm going to appeal to an immigration court, and they can look at my case. So you have to have, so there's these protections in place. They're guaranteed protections under the withdrawal agreement. So it's just to ensure that people don't lose their status based on arbitrary decisions. And this is really important, because we'll have more details about the policy, because we don't know loads about the policy in terms of what the Home Office, they haven't published a lot of information about how they'll do it. So when they do, we'll come back and talk about it. But what we want to emphasize for people is that if the Home Office intends to engage with you about potentially removing pre-settled status, they will use your contact details in your UKVI account. And that is how they will communicate with you, because your UKVI account has your email address, it has your telephone number. And this is what the Home Office will use to communicate with you. So if your email is out of date in your UKVI account, please sign in, update it. Same with your mobile phone number and an address. The Home Office tends to write to people less, but do it anyway. Because you don't want to miss this kind of communication, because it's really important. And we would be worried that people might not receive information. And it's the same with the automation process, because the Home Office will communicate using your UKVI account details about automation. So it's the same. If you want to hear about being automatically moved to settled status, they will send that confirmation to your account. So please ensure that it's up to date. If you know people who don't really engage with the IT so much, encourage them. If you've got people who are like, no, I never update it, it's important. So please do. Okay, and we will come back and talk about this more. I don't want to just touch on it. But at the moment, we don't know loads more about what's going to happen, so we need to wait for that detail. Okay, and I think the last thing I was going to talk about in 2025, before I do some questions, is about what is called universal permission to travel, but some people will refer to it as electronic travel authorization, or ETA. It all is part of the same thing, which is that the Home Office from the 25th of February will require EU travellers to the UK to hold a permission that can be verified by the carrier. When we talk about carriers, we often talk about airlines, but just to be clear, you could be referring to Eurostar or to ferry companies, because they also bring people to the UK. And so what these carriers will be doing is checking your details with the Home Office when you aim to travel, and they will be looking for a permission, the right permission. If you're a visitor, so if you're not someone who lives in the UK and you have no connection to the settlement scheme, but you want to visit the Tower of London, from the 25th of February, the Home Office is going to make the carrier bringing you to the UK check you have an electronic travel authorization, ETA. You need to have that. If you don't have it, the carrier will say, we cannot bring you, because if we do, the Home Office will fine us. Even though ETA is currently applies to EU nationals, it's not fully enforced. So what we're talking about from the 25th of January is full enforcement. Okay, so that's it. That's for visitors, though. So if you've got family visiting you, make sure they're aware. Like, you know, we assume when we do these sessions, we're mainly talking to people who live in the UK. So you guys will probably be exempted from ETA because of your EU assess status. But you'll inevitably have family, you'll have friends who might come and visit you. And if they're EU nationals, then they need to have an ETA to do so, and they will face problems. They will not be able to travel without one. But for EU SS status holders, the pre-settled settled status holders, and indeed for people who have certificates of application, we hope, who are waiting for a decision, it will be your status that gives the carrier the permission. So what they would do is you arrive at, or you check into your flight with your EU passport that is linked to your pre-settled or settled status. The Home Office tells the carrier this person's got. They don't tell them they've got pre-settled or settled status. They just say they have permission. So here's a code that you can allow that person to travel. So, but it works on the basis that your traveling document that you're using for your travel is connected to your UKVI account. Because if it's not connected, then the Home Office sends a message to the carrier and says, well, you need to check, because we don't have a record of this person, so we don't know. They may have permission, but we don't know. And at that point, the carrier has to then potentially look at a share code that you can give them, or they can contact the Home Office call line and say, well, we've got this person here, this is their passport, this is their biographical details. Do they have pre-settled status? And they go, yes, they do. And then the carrier might allow you to travel. But you're into an area where you're relying on the carrier to make investigations for you. And when they're under a lot of pressure to board lots of people via a gate within, a half an hour time period, like, you can't guarantee the carrier is going to do those investigations. And so linking your travel documents to your UKVI account cuts out, ideally, hopefully, if the system is effective, cuts out that need to do so. So it's really important. I've just, so 2 messages about UKVI accounts. 1, update your contact details. 2, update any travel document you use. If you have 2 EU nationalities, attach both passports. If you have an EU passport and an EU national ID card, attach both documents. The account can have more than one, but make sure what you're traveling with is on there, because that's how the system is supposed to function. That's how it functions at its best. Okay, so that's a really big change. That is a really big change, and like I say, it's also about people visiting the UK from the EU, but it has a knock-on impact for people living here, because you have to keep your status up to date. Right, I've got some questions. Thank you very much for posting them, and I'll see what I can do with getting through them. If you need to talk to someone about your case, because obviously we give information at this point on questions, but I'm not giving individual advice. It's not the right forum. If you need to go and speak to someone about the settlement scheme or anything like that, then make sure they're regulated, make sure they're an advisor who is qualified to advise on the settlement scheme. You have to be regulated in the UK to give immigration advice as a service. It is a criminal offence not to do so. Check with people if they are regulated. It's important that you get the right advice. Right, okay, so I'll run through the questions and hopefully give some information. So first question we have is someone's father, who's a non-EU family member, has received an automatic pre-settled extension for 5 years. The settled status application was submitted in August, but they have not received any answer on this application up till now. Called the EU helpline, the resolution centre, and the information they've been given is that it's with a caseworker and takes as long as it will take. I guess that, so the question is, is this acceptable? Is it unusual, I guess, for that to be pending, like an application for 4 months? Yeah, for a family member it can be. There is no time frame for the Home Office to decide. They should decide things quickly and efficiently because it's better for them to do that way. But there's no standard that says you must receive an outcome within 4 weeks or even 6 months. It is a case-by-case basis. The Home Office on gov.uk publishes some information about processing times, and says the cases that might take longer, but typically family member applications do take a bit longer than if you are an EU national. But I don't, 4 months isn't an extraordinary length of time, so fingers crossed there's no reason, hopefully, that your father wouldn't get a grant of settled status coming at some point soon. Okay. Someone's asking, is it better for their missus to apply for settled status as a non-EU national at the same time as the sponsor, who is an EU citizen, both eligible to apply in 2 days because they're both currently on pre-settled status, so coming up to the end of the 5 years? It is a good question. There's no, it probably helps in, you cannot link adult family member applications to each other in terms of sort of submitting them in the same application. It has to be a separate application for yourself and then for your spouse or your partner. So there's no need to do it together. In theory, it makes more sense for the EU sponsor to have settled status in place, because then the Home Office knows that you've been resident for 5 years and so can look at your partner's situation after that. But even if you lodge the applications at the same time, then, as I just said in response to the previous question, family member applications take longer anyway. So your application is likely to be dealt with sooner anyway. So even if you lodge them on the same day within minutes of each other, your settled status grant subject to qualifying will come sooner than your spouse or your partner's anyway. So I don't see any reason not to lodge them together if you're kind of basically relying on the same qualifying period. So yeah, but if you, as I said, if you're still unsure about what's the right way to go about it, speak to a lawyer on a one-to-one basis. But there's nothing I can see that's a red flag there. Right, so we have a question about deportation, which is the implications for a criminal sentence above 12 months where someone has acquired settled status. Are there avenues with the EUSS to challenge the intention to deport someone? I won't be able to cover this in a huge amount of detail because it's an incredibly complex area of UK law. It's also something that is still subject to ongoing court litigation, specifically with respect of criminal offending that has taken place after the 31st of December 2020. There's a couple of cases linked together that will look at some of the really important aspects of this, and so it may be that the approach changes next year once the court's handed down its decision, although there might be further appeals. But ultimately, the UK's policies and law on deportation is that if you commit an offence that results in a sentence of over 12 months or more, you are deemed to be a foreign national offender. You're automatically someone who is, right, we want to deport you, and therefore you need to show us strong reasons why deportation is a breach of your rights. So that's why 12 months is relevant in deportation law, because it's the trigger for an automatic decision that still carries a right of appeal, but is one where the presumption is on deportation. The withdrawal agreement allows the UK to apply this. There's a distinction in the withdrawal agreement between offences committed when EU law applied and offences committed after the end of 2020. So it is an approach that is permitted by the UK. Although, as I say, some of these cases that are being looked at by the courts at the moment are trying to, potentially will narrow down what the UK is required to look at from a withdrawal agreement perspective. So it's an area that will change, possibly. It's a very difficult and complicated area. So that's why 12 months is relevant. Okay. We have a question from someone who's just got pre-settled status as the family member of a qualified British citizen under what's called the Surinder Singh route. And it took 4 years and 6 months to get this decision, which is an extraordinary period of time. Like that is a very long processing time. I'm sure there was lots of potential complications in what's happened there. Obviously, I don't know the full details. So the person's essentially saying is, when are you eligible for settled status? Will the application be on a paper form as it was the first time around? Do you have to send your passports? And they said they haven't left the UK since December 2020, and will bank statements of 3 years and a half be enough as proof of residence? Okay, so when are you eligible for settled status? It might depend on what type of family member you have applied as, but broadly, it's your time is calculated from when you've been living in the UK with your sponsoring British citizen, rather than the date the Home Office grants you pre-settled status, but not in every case. So it would depend on what type of family member you are. I mean, it may mean that you need to take some independent one-to-one advice. Does it have to be on a paper application form? Yes, unfortunately, even though you've been granted under that route, it's still a paper application, and usually that means sending in the passport again. Even though the Home Office have probably held it for such a long time, that's how they work with paper applications. And in answer to your question about the bank statements for the last 3.5 years, will that be enough? Hopefully, the Home Office accepts bank statements as evidence of residence. And you're asking if you need to submit your British spouse's 5 years of residence too. So often the Home Office will ask for residence evidence from the sponsoring party, because they want to know that you've been living in the UK at the same time, because your qualifying period is dependent on your British sponsor. So you may well, it's probably advisable to put in the documents from your sponsor as well as your own residence evidence. As I say, bank statements are deemed to be perfectly acceptable evidence of residence if they show UK transactions. So if you put forward like 3.5 years of bank statements, but they showed lots of transactions around the EU but not the UK, the Home Office might say, well, hang on, this is not evidence of residence. But in the majority of cases, if you're saying you've been resident, so that I can't see why your bank statements would not be sufficient in this respect. So I can answer some of what you're asking, but as I say, in terms of whether you can apply now, it does sometimes depend on the type of family relationship being sponsored. So someone's put a question here saying they've applied through the app for settled status, but the Home Office rejected the application and told you have to do a paper application form. Is that normal? Only if you are applying in a category that has a paper form requirement. Now, we just talked about that very situation in the last question, which was about what's called a Surinder Singh. It's a particular type of application. If you're being sponsored by a British citizen under the settlement scheme, either a dual EU Brit or a British citizen who's spent some time in the EU before coming back to the UK, you have to use a paper application form. If you used the app to apply originally for your pre-settled status, it's quite strange that you would then be moved into a paper application route unless you're changing the basis of your qualifying time for settled status, which could be the case. So yeah, it's an unusual situation, but it's not totally implausible. And I guess the Home Office could have made a mistake allowing you to apply using the app if you were in a route that required a paper application, and now it's like, oh, now they're finding out that when you make your settled status application. So there's probably more to be looked into there again. on a one-to-one advice basis, but it's a bit unusual. It's not something I've heard very often, to say the least. Okay, last question I've received is, we have an EU citizen who is married to a British citizen. They came in 2022 on a family permit through the Surinder Singh route. So again, I'm talking about this more limited route for British citizens under the EU settlement scheme. They hold pre-settled status and are waiting to be eligible for settled status in 2027, based on the 5-year period. They came to the UK as a visitor every year from 2005 to 2019, but have never been resident before 2022. Is there a way to get settled status sooner? No, but I would imagine not. I can't answer any question like that definitively without knowing exactly how much time you spent in the UK. But the reality is that any break between 2019 and 2022 would sever the connection between earlier periods of residence. In all likelihood, if you were only visiting the UK in those that time between 2005 2019. But I can't definitively say, because it's not, as I say, it's not an appropriate forum for that. But it sounds like your qualifying time began in 2022, and that's your 5-year route there. So I would think that is correct for your situation. Okay, very good. Thank you for those questions. As always, I hope that they were able to kind of draw out some of the things that we talked about, and some of and give people information. I'm sorry when I have to say people need to take advice. It's because you absolutely need to sometimes clarify these things and make sure that all your circumstances are considered properly by an advisor. And that's not something I can do via this medium, and it's not an appropriate medium. But hopefully I've given you some steers to look at. So thank you for those. Right, we're at 6:30, so we're on time. Thank you for joining. Thank you for questions. I hope it was helpful. I really appreciate the engagement. We both do. I speak on my colleague Caroline's behalf as well. We'll return in January next year, and we'll start again with looking at those things that we're looking forward to 2026, and we'll be there. And so there'll be more to talk about, and hopefully more information that will help people understand these really important things that are going to be happening next year. So that's it. As always, if you have suggestions, if there's things that you would like for us to cover, and they're things that we think we can do in a way that's helpful to people, then we will absolutely put them on our agenda, and we will organize a session based on that. I mean, we try to base our sessions on feedback that we receive through lots of different mediums, but if you have a specific suggestion, feel free to send it to us. As I say, it needs to be something that's helpful for lots of people. If it's extremely niche, then we might say that's probably not the right thing to cover, but it can be. But we listen to all suggestions, and we do give them their due consideration, and so we're happy to hear from you. But until then, enjoy the festive period. I hope everyone is having a nice break, spending time with family and friends and so on, and we will join each other again in the new year. So thank you for joining, and take good care.